Good afternoon, everyone. It's lovely to see you all. My name's Chris Kessling. I'm Vice Dean of the Inns of Court College of Advocacy, and I'm delighted to welcome Patrick Ryan, who also works for the ICCA, as most people call it, or ICA, who is a Director of Online Learning.
Hi, everybody.
I just want to give a brief introduction by way of this webinar, Mooting and Pupillage Interview Advocacy Tips for Success. We're going to be breaking this down fundamentally into 4 individual parts. We're going to be dealing with preparation. We're going to be dealing with putting forward your argument, your skeleton arguments, your written advocacy, and also presentation, fundamentally your oral advocacy. Just before we start, let me say a little bit about the Inns of Court College of Advocacy and what we do, and a little bit about myself. We, as an organisation, and I guess it's written in the name, are very much focused on advocacy, advocacy training for the practicing bar, for pupils, and also more recently on the ICA bar course, focusing on advocacy there. Advocacy can really be brought down into 2 types of advocacy. The type of advocacy we're focusing on today for mooting, or indeed mainly for pupillage interview applications, is the type of advocacy, I think, Patrick, you called it narrative advocacy earlier. The type of advocacy you would be involved in when you are making submissions to a judge, a single judge or a number of judges, such as in an appeal. That is distinct from trial advocacy, where you're dealing with examination in chief and cross-examination in particularly, as well as, of course, opening and closing speeches. So we're not dealing with trial advocacy today. We're dealing with fundamentally what we call at the ICCA submissions advocacy. So that's going to be the focus. And it should be of assistance to you, both in your mooting and indeed in any applications you make for pupillage, where you're called on, often at second round interviews, to engage in an advocacy exercise. A little bit about myself. I'm a barrister. I'm still a practicing barrister, not that I get to court very often these days, but I was a full-time practicing barrister for 21 years. I started in a general common law set, but actually moved on to specialise in crime. I'll hand over to Patrick for a moment, so perhaps you can Patrick can give an introduction about his background and advocacy experience.
Sure, thanks, Chris. Hello, everyone. It's lovely to be with you for this hour. As Chris says, my name is Patrick Ryan. I was a barrister. I'm no longer a practicing barrister, but I was a practicing barrister for 7 or 8 years on the Northern Circuit, based up in Manchester, where I am today. And my practice was predominantly criminal, with a little bit of other things sort of laced in from time to time, a little bit of civil practice and a little bit of regulatory work, but the majority of my time I spent in and around the criminal courts. I stopped practicing in 2010 and moved into teaching on the bar course up in Manchester in 2011. I did that until 2018, when the ICCA opened, and I went to work for the ICCA. And I've been there ever since. The other thing that I do when I'm not working at the ICCA is I train, do advocacy training for pupils and new practitioners principally on the Northern Circuit. So that's training people who are in the middle of the second stage of training as pupil barristers, and also those who are kind of 3 or 4 years call, who also are required to do further advocacy training when they're that far into their practice. Does that cover it, Chris?
Yeah, absolutely. Thank you, Patrick. So what we're going to move on to now, this is the part when I talk about preparation, which is what we're going to be dealing with. There is a bit of a collective sigh, because everyone thinks, well, I know what that's all about. In fact, I have said to many barristers and indeed students that preparation is absolutely key. And again, there is a little bit of a yawn that happens at this particular stage. That is until Dinah Rose, then QC, now Casey, came along to speak to our students not so long ago. And when she talked about it, they seemed to be extraordinarily interested in the concept. And I think that's because it was Dinah Rose saying it rather than me. Nonetheless, I'd like to focus on this. And in fact, I'm going to quote something from Dinah Rose, because she said this: "The most important work that ensures your advocacy is effective occurs before you go into court. Know your case intimately and entirely. Be familiar with every fact, every document, and with all relevant case law." I think that's really, really useful advice. It's very easy to skim over the papers and get involved in what you think and what many people think is the exciting bit, which is getting on your feet and actually addressing the audience. But that intimacy, if you like, with the case and the facts of the case, and indeed the law, is all important to be able to ensure that in fact what you are presenting is accurate, effective, and of course it is persuasive. So know your case, know your documents, know your law. I think it's worth, when you're starting out on a case, really to focus on what you're seeking to achieve. After all, this is a very solutions-focused job, being a barrister. If, for example, you're an appellant in a case, you'll be seeking to undermine the decision in the court below. If you're a respondent, you'll be seeking to support that decision, perhaps by adding some additional reasoning to it. You might, in a pupillage application, be making a bail application, for example, in a criminal set. If you were for the prosecution, you'd be seeking the remand in custody of the defendant. If you were for the defence, you'd be obviously hoping to keep the defendant out on bail. You might, again in a criminal set, be doing a plea mitigation. Your fundamental task there would be to keep the sentence as low as possible. My advice to all of you, whatever stage you are in advocacy, is to develop a system that works for you. Everyone has a different system. I can tell you what mine was if I was working through a case. I'd take the brief. That used to be paper back in the day. Now, of course, it comes through in a slightly different way online. You used to take the tape off. It was pink for the defence. It was white tape for the prosecution. And you'd open your brief up and you'd start to move through it. And I actually used to start, as I went through, going through every document, writing really what the story of that case was in as much detail as required. And you get to know after a while where you really need to look, particularly in a criminal case. So what you can really focus on and what you don't need to focus on so much. But the reality is you need to go through everything comprehensively to ensure you've got all the detail. It can also be extremely useful whilst you're doing that, almost on another piece of paper, to create a chronology of events. So you actually see, particularly in complex cases, you actually see how matters developed over time. And it's really interesting because the more you do that, it can be extremely revealing. And for me, writing the brief out and creating a chronology really made sure in my own mind that it was actually embedded in my brain. And even though I'd have all of these notes with me, in fact, I wouldn't really have to make reference to them. I might underline a number of parts, but the reality is I knew that story. So, Patrick, what approach did you take when you're given a new brief, a new set of papers, and you've obviously got to go into court at some time and present that case to a judge?
So, Chris, I think I completely agree with you about the value of a chronology. I think it's valuable in crime. I think it's essential in a civil case, and it's essential in an appeal. And most of the mooting that anyone does will be based on appellate advocacy. So you're very much in the territory of appeals. The reason it's essential in an appeal is because you've essentially got two chronologies to manage. You've got the chronology that Chris was talking about the facts of the case, but you've also then got a chronology of what's happened in the litigation itself. And so you've got to ride those two chronologies side by side. But coming back to Chris's point about preparation, for me, the starting point always is to remember that you are one cog in a more complex machine, and you always have to remember what the machine is doing. The machine, which is the court process, the litigation process, is trying to arrive at an answer to a question. Two sides in any case, criminal, civil, appeal, come before the court with competing ideas and competing arguments, and they ask the court to decide their case. Normally that will be a single judge at first instance, or it will be a panel of judges on appeal. But remember that that's what the court is there to do. It's there to decide a question. So very early on in your preparation, you have to start thinking about what is the question at the end of the case that the judges are going to have to answer. And then for you, the task becomes, as the advocate, how do I assist the court to answer the question in a way that is favorable to my client? And if that's at a sentencing here, if you're at a pupillage interview and you're asked to do a plea and mitigation, as Chris says, the question for the court is, what is the appropriate sentence for the defendant in these circumstances? And your task as the defense advocate is to help the court to come to the decision that the lowest possible sentence available can be imposed on this defendant in these circumstances. In a moot, the problem might be slightly different. The question for the court is, should I uphold the decision made by the judge at first instance or overturn it? And your task will be, as the advocate, to present the case to prepare the case and then present it in such a way as to help the court come to the answer which is most favorable to the side you represent. Is that helpful, Grace?
Yeah, absolutely. Thanks, Patrick. So the reality is this: work out what exactly do I want to achieve here. Make sure that you are absolutely familiar with all of the documents in your case. You've created your chronology, if that's going to work for you, and then of course you get to the law. In a lot of moots, you're going to be starting really reading the judgment of the court below, and you're going to be deciding whether that fundamentally supports you, whether it doesn't support you, what other case law is there, and of course you're going to have to do your research. I'm going to talk a little bit about how to do that in a way that's going to be, I think, helpful to you. But fundamentally, I would say, as you're working through your case, be critical of your own case as you do, because that allows you really to think, what are the points fundamentally the judge is going to make in my case when I'm actually putting forward my various arguments. So let's move on to your argument. There's a wonderful quote that I'd like to use from Lady Justice Andrews. And she said this really about the concept of persuasion. How would you explain to a friend who gets easily bored why you should win? And I love that, because actually it focuses really on the nub of the issue. What is it about your case that makes it a winning argument? And you should know when you go into court what that is. That in itself gives you a sense of confidence. On the concept of persuasion, when you get into practical advocacy, it's very, very different from the sort of advocacy or the sort of research that you do when you're doing academic law, such as on an LLB or a master's degree. Because there you're looking at cases, you're tearing them apart, and afterwards you're thinking about solutions. Where it's different in practical advocacy, you're essentially putting forward a proposition and then you are supporting that particular proposition. I'll explain that a little bit more. What you want to avoid as an advocate is a judge saying to you, why? Because if you just put forward a proposition such as, I would make an excellent barrister, if I haven't said why I would make an excellent barrister, don't laugh, Patrick. If I haven't said why I'd make an excellent barrister, then I'm obviously going to get the question, why? So each proposition you put forward should be clearly supported. And that's going to prevent you ever being asked the question why. And it's the quality of that support that really makes for good advocacy. And I can tell you what it's like when you're judging a moot, and I judge a lot of moots. When you have a really good advocate in front of you who is making their submissions, if you think that submission is made of those two parts, proposition, support, proposition, support, proposition, support. Each argument or each submission they're making, which is so well supported, really prevents you butting in to say why. As long, of course, as the supporting evidence, whether it's case law, whether it's statute, whether it's factual, is meaningful. But that is the key to actually making this really useful. So when you're using case law and statute, start by summarizing what you say is the correct proposition of law, for example, and then show the court the case or cases that demonstrate why you're correct. A very simple example would be, for example, you could say, in my submission, whilst an intention to cause grievous bodily harm would be sufficient for the offence of murder, it would be insufficient for the offence of attempted murder, which requires a specific intent to kill. In support of that, I rely upon the case of Wybrow, and then you tell them about the case of Wybrow. You could take them to your bundle and take to a particular passage. That's really useful because the judge knows what your proposition is. Here is my proposition, and now I'm taking you to the support for that proposition by looking at this particular case. What you often do in academia is you do it the other way around. May it please your ladyship, I'd like to take you to the case of Wybrow. And so the judges are immediately thinking, why? Why am I looking at this? Then you open the book, you take them to your bundle. Please look at page 5,420,000. You open that up and paragraph E, yes, I've got that. And you start reading part of the judgment. And then there might be another part of a judgment. So if you could just move 2 pages forward to paragraph D, and then you read that. Now, that's all well and good, but just think about it from the judge's perspective. At no stage has the judge actually yet realized what the point is you're making. And I can promise you this, because I've done it wrong myself. All of us have. I bet Patrick has too. You realize just looking at the face of the judge that actually something is going awry, because it's the wrong way round. Proposition comes first, then move to support. And you follow that fundamental principle, it's easy for the judge to follow. The judge always knows what point you are making. And it may well be that once you've made that proposition, before you've even got to the relevant page on in your bundle of case law or statute, the judge will say, yes, Mr. Kessling, I accept that. Please move on, which is great because the judge recognizes where you're going all the time. So I hope that makes some sense. Patrick, have you ever fallen into that trap yourself? You don't have to confess.
No, I know. This feels very much like a moment to confess endlessly. And one of the things about advocacy is, sadly, there's very few ways to learn how to do it other than by making the mistake a number of times and finally thinking, this isn't working, I have to try something new. But what Chris says is absolutely right. And I think if you take only a few things away from today, please let one of them be this. The task of any advocate is to make the case clear. And what Chris is talking about, and the reason he's telling you to do it in that way is because it has a clarity and a cleanness about it from the get-go. In other words, the moment you start a new submission or a new point, the judge knows what we're talking about. Chris has set out at the beginning his contention, his argument, his proposition that the requisite intent for attempt murder is specific, and it is the intention to kill. So we know what we're talking about. The ground we're going to be covering is clear. Now the question becomes, well, how is it Chris is able to say that? And there he can rely on authority, and that might be case law, it might be statutory, it might be the evidence in the case that is of assistance in the point Chris is making. But the headline is, he has made his pitch entirely clear from the get-go. And if you can keep as your watchword clarity in all things, you won't go too far wrong with this.
Absolutely. I just saw a question come up saying, is the recording going to be made available of this webinar? The answer is yes. All of our webinars will go up on the website. If you go on the Ichabod course, there's a drop-down menu, and there's one that says Events 2022, and there you will find not only upcoming webinars, but also recordings of everything that we've done. So that'll take you directly to our YouTube channel. Chris,
while you're talking, I'll post a link to that in the chat, so people can use it if they want to now.
Thank you very much. Thank you, Patrick. That's the approach, helping the court, getting to the point, keeping it clear, as Patrick says, and keeping it simple, because simplicity actually works. Remember that when you're dealing, particularly with a case that's in a moot, that's an appeal, you can't really interfere with findings of fact below or findings of discretion, the judge's exercise of a discretion. But you don't have to take for granted the way a case was argued below. You don't have to take for granted the approach of the judge below. Just make sure you satisfy yourself of what the law is, or what you feel appropriately can be argued as to what the law should be. Let me give you an example of this. And I'm going to use again, an extraordinary advocate, Dinah Rose QC, who was involved in this case, and it's the case of Unison and Lord Chancellor, a 2017 Supreme Court case. And for all of you that are interested, particularly in hearing one of the strongest judgments that's come out of the Supreme Court, I recommend highly that you read Unison and Lord Chancellor. In that particular case, the government had decided that the Employment Tribunal fundamentally should pay for itself, and they decided to think of people using the Employment Tribunal not as people who were there to exercise their rights to be treated fairly and appropriately, but rather as service users who were there to pay for that particular experience. Matters didn't go well, because what in fact happened, and it's worth thinking about the type of cases that go to the Employment Tribunal: discrimination cases, equal pay cases, but they're not cases that really pay out a huge amount of money, but they are cases that allow people to fundamentally survive in terms of having a living wage, living day to day. And in this particular case, this particular situation, what happened was that the cost of bringing a case to the Employment Tribunal was raised to such an extraordinary and inordinate level that 70%, there was a 70% drop almost overnight of people actually taking their cases there. Unison, quite rightly, decided to bring an action to deal with this. The approach they took was that they did it fundamentally on a basis of EU law, and they, as contrary to something called the Equal Treatment Directive. And that case took an interesting route through the courts, from the administrative court, but it came in the end to the Supreme Court. But before it got to the Supreme Court, a new counsel was employed or instructed, and that was Dinah Rose QC, together with, of course, a number of other barristers. And she took a really interesting and detailed look at this case, along the lines of what I was talking about earlier in terms of preparation, getting to know your case intimately and entirely, getting to understand the law, reading the judgment below. Really an excellent example, I think, of analysis. And she decided that, in fact, the Equal Treatment Directive approach wasn't the best approach. The best approach, in fact, to consider this case as part of the fundamental common law right of access to justice. Very much, she thought, and was proved to be correct, in the sweet spot of the Supreme Court, and that case was argued. And the Lord Green for the Supreme Court, who gave the judgment, as I say, it was one of the strongest judgments that certainly I'm aware of that's come from the Supreme Court, and that was a success, and it was a success that certainly Dinah Rose, when she spoke to the students at the Inns of Court College of Advocacy, said was certainly for her one of her greatest. It was an extraordinary win. But it took the ability to analyse a case, stand back and think, actually, there's a better way to do this. So that is something you might do, but I would say be careful. Be very, very careful, because sometimes actually you're far better just looking at the case and distinguishing a particular case on the facts. What does that case really mean? Does it mean what the opposition said in the court below, for example, or is there another way of actually analysing this? I tell you to be careful because things could go another way. This is a case I was involved in back in 2007. It was a case that in fact involved a lady who had been arrested, and she'd been taken to a police cell where she was extraordinarily aggressive and racially abusive to a police officer. This happened in a police cell, and the charge was a Public Order Act charge. And there was a defence essentially written into the statute that says if your conduct occurred in a dwelling and the other person was also in a dwelling, then no offence exists. So, and I won't use his name, because I'm being nice.
Wasn't me, can I just point out?
It wasn't.
Because I know what's coming.
So I went off to court one morning, to the Crown Court, to do this trial, and my opponent, no names, no pat drill, I won't say who he is. Nonetheless, he came along and he said, "Oh, I've got a really, really good argument." And I said, "Really? What is it?" And he said, "Well, actually, I think this isn't an offence because this occurred in a cell." And I said, "Yeah." And he said, "Well, that's equivalent to a dwelling. It's equivalent to her home." And I said, "Really?" And he said, "Yes, because if you think about it, that's where she does her ablutions. You know, there's a sink there, there's a bed there, there's a toilet there. This is, to all intents and purposes, a dwelling." Now, I made the mistake that it's very easy to make for any barrister, where you effectively laugh an argument off. You think that's ridiculous. You go into court, you don't take it too seriously. In short order, I lost that argument. The judge found in favour of the defence and ordered the defendant's acquittal. But I knew enough about the law to realise that as the prosecution, I was entitled to appeal what's called a terminating ruling. So I spoke to the CPS and we decided that it was worthwhile doing in this particular case, which had the effect of, when I told the judge we were appealing, of staying the acquittal. And the next thing, we're in the Court of Appeal. And in the Court of Appeal, things went very well for me because I stood up to present the case and they said to me in that very nice, motherly, fatherly way, we needn't bother you, Mr. Kessling. And my opponent got up and he was metaphorically kicked around the courtroom for the next 20 or so minutes. And they said to him, no, there is no way this is a dwelling. And I'd just like to read you the final part of that judgment, because it says this: "We respect the achievement of counsel for the defence in convincing the judge that a police cell was a home. But sometimes early forensic success meets its nemesis in this court. When a bright idea strikes counsel as a moment of epiphany, it is useful for the advocate to recall the advice of that illustrious member of the modern jazz quartet. Miles Davis advised, think of a note, don't play it." I love that. In reality, of course I love it. I was on the other side and I was smiling away very jolly and went out for a nice lunch afterwards. But by the same token, I think the point is this: just because you can doesn't mean you should. Think carefully. if you can properly justify, i.e. support the arguments that you are putting forward to the judge. And if you can, and you can in the cold light of day, and you think, yeah, this is really worthwhile, then do it. It's particularly important in mooting, I think, because remember, in mooting, you often have, 12 or 13 minutes to put forward your case. And it's very easy to fall into that trap of thinking, oh, I've got all of these arguments. Let's say I've got 10 arguments. And then let's say you take 2 minutes off for questioning. You've got a minute for each argument. And actually, what you often get judges saying is, what are your best points? Because judges don't want to hear weak arguments. Judges want to hear arguments that are properly supported, that you can properly put forward, and that make sense, and that are clear. Are you doing the best for your client by putting all of these arguments, or actually can you jettison some of these? Is there anything you want to add on this, Patrick?
No, because I wrote down two things when you were talking. One was bad points that you've just dealt with, and the message is, you're absolutely right, is try to avoid them. But identify them early and get rid of them early would be the key things on bad points. I suppose there's a slight twist on the question of how you deal with weaknesses in your own case, because you might well have a series of good points to make, but there might be things in your case you're looking at, you're thinking, that's not great for us. And always think with a moot, the only point of a moot problem is that there is at least one or two arguments to be deployed on either side of otherwise there's no point in having the moot argument. So there are going to be things that the other side can say that are helpful to them. And there's an interesting question about how you deal with points that are against you or points that are weaker on your side. I think my view always is the best advocates are those that are able to identify the weaknesses in their case. They don't shy away from them. If they're questioned about them, they acknowledge that is a strength in the other side's case, and there may be a partial answer to it, or there may be no answer to it. The real skill, I think, comes in persuading the court that, notwithstanding the weakness that the court has identified, your client can still win the case. The judge can still find for you. In other words, the point can't be logically argued away, but the point isn't so significant as to drive the judge to a conclusion that is contrary to the argument that your client wants to make. In other words, you can say, yes, judge, we acknowledge that is a good argument, but the case turns on this point. And on this point, our client has to be successful for the reasons we've already discovered. So it's a way of neutralizing the weakness, acknowledging it, which is a very good thing to do. Don't try and persuade a judge that a weakness is not a weakness, or that is in fact a strength, because you will only end up making bad points, which is what Chris has just told you rightly not to do. But find a way of packaging off the weakness in your own case, and explaining to the court why it is that you can still win the case, notwithstanding the existence of that weakness.
Yeah, thank you. Okay, I'm going to move on now to skeleton arguments. Fundamentally, of course, this is written advocacy, and very often advocacy is formed of court advocacy is formed of those two parts. It would be your written argument, your skeleton argument, and indeed your presentation, your oral advocacy. And we're going to be dealing in a moment with oral advocacy. But the first thing I would say about skeleton arguments, and if all members of the Court of Appeal were here with me, that they would be nodding, I promise, is this: quality, not quantity. A skeleton argument is deliberately, it's in the name, meant to be skeletal. It's meant to be brief. It is not meant to be a script. It's not meant to contain every single part of your argument. It contains the fundamental key parts of your argument. And then when you stand up in court, you amplify, you enlarge upon those arguments and bring them to life in a more detailed way. But it enables a judge to read into what your argument is. selective and economic in the way that I was talking about earlier with the arguments that you use. Don't try and throw everything into this. Make it as clear as you possibly can and set out as concisely as you can why your position is correct using that technique of proposition and support. I contend X because of Y, okay? And again, that it will really help you. Remember that a skeleton argument effectively sets out the structure that you are going to adopt in court. Not in every sense, but fundamentally, let's say you've got 3 arguments. Well, set out those arguments in the order that you're going to be using them when you're in front of the judge. And when you're in front of the judge, say, for example, my lady, turning to my first argument, in relation to this, I have 3 submissions. You can see this is set out at paragraph 12 of my skeleton argument. Signpost as you go through. That's very helpful. But don't fall into the trap of reading your skeleton argument, because the judge will actually find that slightly offensive, because there is a hidden suggestion in that the judge, him or herself, hasn't read that for themselves. So don't use it as a script. Think of it as something that should be, again, clear, really helpful to a judge, to allow them to get a really good oversight of what your case is all about. I can tell from your face, because I know Patrick well enough, that he's burning to say something on this point. Over to you, Patrick.
I don't want to interrupt your flow, Chris.
Not at all. Not at all.
To say, I completely agree that in a skeleton argument, the key to clarity is the structure of it. And there are, I always think, 2 sides to the structure, or two parallel ideas running simultaneously. One is the external structure of your argument, which is what Chris has just been talking about. The points you want to make, packaged in the order you're going to make them, with an introduction and a conclusion at the end. The other structure to be aware of, and this is really where you're into some higher level advocacy, is the structure of the individual point in the skeleton argument. And I think if you remember what Chris told you a little earlier on about giving the proposition to begin with, and then the supporting arguments in favor of it, whether they are case law, statutory, or evidential, then you will not go too far wrong with the internal structure of each individual point, so that the argument hangs together as a coherent argument, but that each individual point hangs together coherently as well. And the judge is never unclear when reading it what it is that you're asking for at any particular moment.
Thank you. Yeah, I totally agree with that. I think it's also worth making this point about the skeleton argument. Take pride in the physical appearance of the document. Don't try and cram it and use, you're usually told, particularly in moots, you know, don't use less than 0.11 font, for example. But if you're not, just don't use less than 0.11 fonts, because it becomes too small. It's very easy to cram a piece of paper so that, in fact, it just looks like a sea of letters, as opposed to actually a nicely spaced document that you can make sense of. Again, it's about helping the judge. It's about actually making it as easy as possible for your audience to understand your argument. And if you think of the judge as your friend, they may not look like your friend, I promise, but think of them as your friend. I'm going to come back to this when we're talking about answering questions. If you think of them as your friend before actually you've even met them, that's really, really helpful. The chances are, in fact, for you, if you've done this well, a nicely spaced, well-presented document, before they've even met you, it gives you a level of credibility. It gives the judge a level of confidence in you as an advocate. And that is a great advantage before you've even got on your feet. So think about it in that particular way. There's another a really nice thing, I think, that actually happens in practice, that when you do a case and you are successful, that skeleton argument often forms a significant part of the judgment of the court. I remember that first happening to me when I had to go down to the Royal Courts of Justice to do my first ever judicial review. And I'm not afraid to say that I was utterly petrified at the time. I thought, oh, it's all come to this, you know, this magic moment. You could smoke. I used to smoke in those days, and you could smoke in the Royal Courts of Justice. I remember standing there. For those of you who haven't been to the RCJ, when you walk in, it's cathedral-like. It's vast, and I was standing. There's a balcony at the end, and I was standing there smoking about 100 cigarettes. I think that's what turned my wig yellow after a while. And anyway, I went into court, and I succeeded. I was in front of the Master of the Rolls. That's why I was very, very scared. And but I succeeded. It was great. The case got into the Times. It got reported, and there, as they were reading their judgment out, I could hear that fundamentally what they were doing, with some well-advised alterations, I hasten to add, where they were basing their judgment fundamentally on the skeleton argument I put forward, and that's great. It meant actually that I'd done my work well. So. That is a nice thing that will happen. And again, even in a moot, when a judge is, I say even in a moot, when a judge is giving his or her judgment, you'll often see the same thing happening. So it can be so useful to do that. Remember, of course, your opponent's skeleton argument, make sure you read that really well, because you really need to set these two documents side by side, your document, your skeleton argument, theirs, because that will really delineate where the areas of dispute are between you, and that will really help you focus, because that's exactly the process the judge will have gone through themselves. Patrick, you were going to say something, I think.
Only to endorse what you were saying, Chris, and just to say it's a really good check before you send off your skeleton argument to whoever you're sending it off to reread it in that way. In other words, could I rewrite this very succinctly to be the judgment in the case? Is there enough here? And is it packaged in a way that will allow the judge in my moot to simply adopt my skeleton argument as the answer to the problem? If the answer to that is no, you've probably got a bit more work to do on your skeleton argument. It's quite a good barometer of whether it's ready to see the light of day or to be shown to other people. It can't read like a judgment because you're not making the judgment, but it should have all the elements there that will allow the judge to say, for these reasons, 1, 2, 3, I'm going to allow the appeal or refuse the appeal. And if you can put your hand on your heart and say, yes, it does that, it's probably ready to go to somebody else.
Many ways, it comes back to that wonderful advice from Lady Justice Andrews. How would you explain to a friend who gets easily bored why you should win? Keep it clear, keep it simple, keep it persuasive. Proposition plus support. Okay, we're going to move on now to presentation, your oral advocacy. So you've done all of your homework, you've got your skeleton argument, you know your case and your papers intimately and entirely, and you know your law in the same way. So now, of course, you've got to put this forward. You've got to stand up and you've got to address the judge, and you need to do it in a way that is as effective as it possibly and persuasive as it possibly can be. Patrick and I do a lot of tuition in terms of advocacy, and in the process of doing that, we see a lot of errors, and we ourselves as advocates have made a lot of errors. I think to all of you, particularly those of you that are starting off in this process, just remember, I've talked about Dinah Rose QC and this extraordinary and illustrious advocate that she is. By the same token, remember that there would have been a time where she stood on her feet and addressed an audience for the first time. Everyone has to start somewhere. And it is something that you continue to learn about and learn from others as you do it. But for the whole of your career, you go around, I think you become a bit of a thief as an advocate, because you go around and you take a phrase from one and you take a phrase from the other. I like the way you did this. I like the way you did that. I like the way you put this argument forward. And you pull all of these various bits together and actually add a little bit of your own, of course, And that's actually what makes you unique as an advocate. And it works really well. And all barristers fundamentally do the same thing. But the first thing I'm going to say to you is think about pace. I'm someone who can speak very, very quickly. I know that. But by the same token, I've been speaking for many, many years, and I can probably speak quickly reasonably well. A number of people I know can speak quickly reasonably well, even people who are at the beginning of their advocacy journey. Others can't. But I think of it like this. Very often when you see people who are speaking too quickly, their mouth in reality is ahead of their brain. So what happens is that you find that people start stumbling over their words, that they're not articulating their submissions as eloquently as they might otherwise be. And they fall therefore into a massive confusion and they lose their way. Whereas if you think about it the other way, if you moderate your pace, your mind, your thinking brain is actually ahead of your voice. It gives you the ability to think ahead. It gives you the ability to think on your feet. That's something all of you will have heard about barristers. It gives you the ability really to work out how most effectively you're going to articulate your submissions to the judge. So pace is something you have to practice. All of us, particularly when we get a little bit nervous, speak too quickly. So tone it down a little bit. Patrick, would you say that you've experienced, in terms of advocacy tuition, the same problem?
All the time. And it happens to advocates at every level of their career. Chris and I see people at the very outset of their career at the ICCA, and we see people a little bit further on down the line, and then we've both seen people in court, and it bedevils people right the way through their career, and there will be different things that cause it at different times. Chris is absolutely right. The most common cause of speaking too quickly is because you're nervous. That's generally what happens. You get nervous, you get anxious that you're not going to be able to get to the end, or you want to get to the end as quickly as possible. You want to stop the judge from interrupting you. So if you just create this wall of sound, you'll be allowed to go all the way to the end of the point and no one will interrupt. That's not true. You will get interrupted. And the way to combat that is to be aware that that's the first way to combat it is to be aware that that is the case. You will be nervous because this is a nerve-wracking thing to do. And you should be nervous. I think, well, I would certainly say for myself, I don't want to speak for Chris. Even after doing the job for 7 or 8 years, I felt a lot more comfortable and confident doing it, but there were still times I got nervous. There are still new things that happen, or things that happen you weren't expecting, and you think, crikey, I've got to respond to that, and your nerves shoot through the roof. Acknowledging that and then realizing how that impacts on your performance is half the battle to being able to fix it. One of the other key things is you should never be standing up in a moot or in a pupillage application, a pupillage advocacy exercise, saying those things for the first time. Practice is really important. I'm sure Chris is going to come on to talk about this, but it's one of the ways, if you know what's coming next in the argument, if you know what submission comes next, it's much easier to control your nerves, control your anxiety, and therefore to slow down your pace.
Yeah, I totally agree with that. Practice is so important. And, you know, if your mum and dad, your brother or sister, your boyfriend, girlfriend, who you live with, have to listen to you being an advocate, well, so be it. Use them, use your friends. And it's so helpful just to actually stand up and actually make your submissions to them. And it's really interesting that when you actually stand up and do it, very often you recognize the flaws in your own argument. I know that sounds like an odd thing to say, but voicing them, articulating them, in a way makes them far more real than just seeing them on the page. So I couldn't agree more. It's so useful in terms of understanding your argument. But of course, in terms of the context of oral advocacy, just making sure that your presentation is as effective and persuasive as you can possibly make it. So I'm going to move on from pace to the next problem that very often occurs with junior advocates, if I can put it that way, which is reading. And very often pace and reading go hand in hand. We've heard about, as Patrick has rightly said, about nerves. That's another reason. But reading really strangles the life out of a performance, because for a number of reasons, you're not looking at the judge, you're looking down. Very often you're reading very, very quickly. Very often what you do when you read is that you try and employ false intonation to make it sound like you're not reading when you know full well that you are. And I can promise you, the judge will know you are as well. It simply doesn't work. In broadcasting, they call it, with a good broadcaster, whether or not your voice lifts off the page. And some people can read very well and other people can't. But whether you can read well or you can't, you should not be reading at all. You should be using notes as an aid memoir to assist you. And I think the best advice I can give for that is to actually keep your notes reasonably sparse, have headlines of the fundamental points you want to make. You might want to make annotations on your skeleton argument and use no more than that. But what you do not want to end up with is a script. A lot of people say to me, oh, well, I took the script in because just in case I forgot, I forgot everything I was going to do. And I say to them, well, hold on, if I took you out for a coffee right now, we sat down and I asked you what this case was about and what your argument was about, you'd be able to look me in the eye and tell me straight away, wouldn't you? Yeah. So why on earth do you feel that because you go into what is, I accept, a slightly more formal environment, do you suddenly lose your way? That's a question of just calming down, saying, I can do this, and using the nerves to actually energize yourself, channel that energy, channel that nervous energy into something that's really, really positive for you. It's going to make a huge, huge difference. Because I can promise you, even though taking a script in feels in some way like it's a safety net, that net will unravel and it'll go around your neck and it'll strangle the life out of your performance. So this, again, I go back to what Patrick said about practice. If you practice, this will come to life for you. It will make real sense to you, and it will give you that level of confidence before you go into the courtroom or before you go into the pupillage application to be able to do this. Deep breath, move on. I can. That's what I would say about that. Anything you want to say, Patrick, about reading?
One thing, and it's an entirely practical tip, just to come back on what you said about the managing the nerves. Some very interesting research from Harvard Business School about how people in high-powered meetings manage their nerves. They took 3 groups of people and they said to one group of people, just do what you normally do, which was to get nervous. And they got nervous. They said to another group of people, try and be as calm as you can before, and slow down your breathing, relax, and calm yourself down. And to the third group of people, they said, instead of saying to yourself that you're nervous before you start the whatever it is, the meeting or in this case, the piece of advocacy, say to yourself, I'm excited. And one very interesting happened. The people who had relaxed were slightly better than the people who were really nervous, but not discernibly so. The people who said to themselves, I'm excited, performed at a much higher level. And if you want a 2-word tip before you start your next moot or your next bail application or in a pupillage advocacy interview, just say to yourself internally before you get up, I'm excited, and see what happens.
That's fabulous advice. And yeah, again, if you could just, we recognize nerves are they can be really difficult for people, obviously. And if you just take that and that makes a difference for you, then it's certainly made this webinar worthwhile, because I know full well it's a real concern to a lot of people for good reason. The next thing I want to talk about is eye contact. In many ways, this relates back to reading, of course. If you're reading, you're just looking down, you're not actually looking forward, you're not engaging with your audience. I was thinking about this. Imagine you'd been out and you'd seen something that you found really exciting the day before, I don't know, a gig, or you'd been to the cinema, or you'd seen a play, or whatever it might be. And you were sitting there the following day with your best mate, and you're sitting there over a coffee, and you are telling them how good it was. You would be looking at them, and they would sense from you, not just in terms of your words, but also in your expression, and particularly in your eye contact. It would really emphasize those points that you consider to be really important. So it's part and parcel of effective oral advocacy. Make sure that you therefore engage with the judge. You might also tell from the judge when you're looking at him or her, actually, this point isn't going anywhere. I'm not getting anywhere with this. And you might say, Your Ladyship, I recognise which is the way the wind is blowing on this particular point. Perhaps I can move on to my next submission. That's quite nice. A lot of judges will acknowledge you and have confidence in you for actually recognising that. So it's not simply starting at the beginning and moving through. You've got to be willing sometimes to alter your structure depending on the circumstances that, as they exist at any given moment. Eye contact is a really good way of doing that. So again, practice will really help you do that. Patrick, would you say that eye contact is another issue, particularly for people starting out in advocacy?
Yeah, and I think that the point you make about reading, Chris, is the fundamental one. If you're reading, you can't be making eye contact. It's very, very difficult to make eye contact. On the other hand, if you are making eye contact, you can take all the visual cues that Chris has just talked about. You know when a point is landing, and you can move on because you know you've made the point. You know when a point is failing, and you can change the argument, or you can move on because it's not going to get anywhere. It's utterly crucial.
There's just a few more points. I appreciate what the time is, 2.5 minutes to go, but I think that's fine. I'm always delighted when I ever finish on time, which is quite unusual for me. The next one I want to talk about is actually your posture and your movement, because it's very easy, again, often a function of nerves, to start doing this, waving a pen around, tapping a pen. This one's got a rubber on the end, so it's not going to work very well. But you get the point. Or just shifting around. Even online, you might find yourself rocking from side to side. I've seen that. If you stand with one foot behind the other, it's very easy to start rocking. If you stand side with your feet next to each other, it's far more difficult to rock. If you've got a lectern in front of you, just plant your hands gently on the lectern. Also, don't stand with your hands in your pockets. It looks too casual, and it's very easy to start rocking about. I'm not saying you should stand like a statue, okay? I'm not saying you shouldn't occasionally use your hand to emphasize a point. However, don't wildly gesticulate, because again, that will distract from your advocacy. And whatever you do, just avoid picking a pen up or a pencil up, because you will start waving it around. And you don't want to start pointing it, because that is never, ever good advocacy, and it's certainly not going to be persuasive. The final part I want to talk about, and I get a lot of questions about, is answering questions. That is a problem for a lot of people, not in reality, actually, but mainly in their minds before they go in for a moot or go in for a pupillage application. The first thing I'd say about answering questions is, if you know your case intimately and entirely, and you've prepared it and you've practiced it, it's not going to be a problem. Think of answering questions as a wonderful opportunity to actually assist the judge. Think of the judge as your friend. I was talking about that earlier in relation to skeleton arguments, but in relation to questions, because the judge has asked you a question because he or she wants to know the answer. And that is, therefore, use that opportunity to put your case forward. Make sure that when the judge asks you a question, that you actually listen really, really carefully, because what often happens is you're so keen when you get what the essence of that question is to answer it that you end up butting in. And there's nothing worse for a judge than being interrupted. So be really careful about that and expect that level of interjection and use it to your advantage. Patrick, I can see that you've got something to add to that.
No, I think you've said absolutely everything, Chris. I think listening is the key, and I would go further than just the judge of the questions. Listen to your opponent as well. You should be listening to absolutely everything that happens in the moot or in the hearing, because it will give you clues as to how to put your case better.
Whatever you do, don't try to fudge it in questions. If you don't know the answer, it's far better to say, my lord, my lady, I do apologise. I'm unable to answer that at this stage, but perhaps we can move on to my next point. Don't also say, I'm going to answer it later, and hoping the judge will forget, because the judge, I promise you, will not forget. And I've seen that technique employed a number of occasions, and it never works. Always be polite and courteous to a judge. And also, finally, let me say this, be willing to change your structure, because a judge might say, I'm not actually interested in your first submission, but I am very interested in your third submission. You can come back to your first submission later on, but let's hear your third submission now. Don't at that stage say, well, I'm going to get to that. That's my third submission. That'll just annoy them. Do it, go to your third submission, and then go back to your first one. And because you've done this wonderful thing of having this simple and clear skeleton argument and very simple and clear notes, it'll be very easy for you actually to jump from one part to the other without just seeing a sea of words. Now, I can see I've gone 1 minute over time, which for me isn't too bad at all. I'd like to say to all of you, I very much hope this has been useful. It's been a pleasure to see you all. Thank you from me, and also from Patrick. And as we said earlier, this will be going on the website. The link was provided earlier, but for those of you that can't see the link right now, if you go on the website, ICABAR course, drop down menu, the part that says events, it will later on this afternoon be there. Thank you for coming.
Thanks, everybody. Bye-bye.
Bye.